Welcome to your daily dose of history. In several cases, several suspects were questioned by police, detectives, and prosecuting attorneys and made oral confessions or signed statements without being notified of their rights to counsel or given warnings of their rights. The court reviewed the cases in order to decide if not being notified of your rights is a violation of the Fifth Amendment. These four cases include Miranda v. Arizona, Vignero v. New York, Westover v. U.S., and California v. Stewart. Here's some behind-the-scenes footage of what occurred before the court cases traveled all the way to the Supreme Court.
Are you Ernesto Miranda?
Yes! You're under arrest for rape and kidnapping. Get in the car.
Bad boys, what you want, what you want, what you gonna do when Sheriff John don't come for you? Tell me what you wanna do, what you gonna do? Yeah. Bad boys, what you gonna do? What you gonna do when they come for you? Bad boys, what you gonna do? What you gonna do when they come for you? When you were 8 and you had bad traits, you go to school and learn the golden rule. So why are you acting like a bloody fool? If you get hot, then you must get cool. Bad boys, bad boys.
Miranda v. Arizona. Miranda was taken into custody after he was arrested at his home. He was interrogated for 2 hours by 2 police officers. This led to a signed and written confession. The oral and written confessions were shown to the jury. Miranda was found guilty of kidnapping and rape and was sentenced to 20 to 30 years in prison on each count. After the case was appealed, the Supreme Court of Arizona held that Miranda's constitutional rights were not violated.
Stop that man!
What is this? Is this the man who robbed your dress store?
Yes.
You're under arrest. What?
Bad boys, what you want, what you want, what you gonna do when Sheriff John don't come for you?
Vignero v. New York. Vignero was accused of robbing a dress shop in New York that had occurred 3 days prior to his arrest. He was questioned by the 17th Detective Squad of the New York Police Department and by the 66th Detective Squad, where he actually confessed. He was then taken to detention, where he orally confessed again to an attorney in the presence of a reporter. The oral confession was used against him in his trial. He was found guilty of first-degree robbery and sentenced to 30 to 60 years in prison. Westover v. United States. Westover was taken to the police station after being suspected as a suspect in 2 Kansas City robberies. The FBI received a notification that Westover was also wanted in California. Westover was interrogated that entire night by the FBI and then the next morning by local police. After being interrogated, he signed separate confessions, some of which took place in California. His statements were used at the trial and the jury found him guilty, and he was sentenced to 15 years in prison for each count. This conviction was affirmed by the Court of Appeals in the Ninth Circuit.
This is the evidence against you. Do you have anything to say?
I stole her purse, but I didn't mean to hurt her. California versus Stewart. During an investigation for purse snatch robberies where one of the victims actually died of injuries, Stewart was accused of being an endorser for stolen checks in one of the robberies. Stewart was then arrested at his home. Stewart was put in a cell and interrogated over the next 5 days 9 times. Stewart admitted that he had robbed the woman but did not mean to hurt her. Stewart's statements were used at the trial. Stewart was convicted of first-degree murder, robbery, and was sentenced to death. The Supreme Court of Arizona reversed the decision, saying that Stewart should have been advised of his rights to remain silent and his right to counsel.
The defendant, Ernesto Miranda, was not notified of his Fifth Amendment rights when he was arrested. Therefore, the self-incriminating evidence used to convict my client should be discarded and the case thrown out.
I, Gary Nelson, speaking for the people of Arizona, believe this is not a Fifth Amendment issue. It is an attempt to expand the Sixth Amendment Escobedo decision. Forcing police to advise suspects of these rights would seriously obstruct public safety.
I, Chief Justice Earl Warren, will read the majority opinion on the cases concerning Miranda v. Arizona. Briefly stated, it is this. The prosecution may not use statements, whether exculpatory or inculpatory, stemming from custodial interrogation of the defendant unless it demonstrates the use of procedural safeguards effective to secure the privilege against self-incrimination. By custodial interrogation, we mean questioning initiated by law enforcement officers after a person has been taken into custody or otherwise deprived of his freedom of action in a significant way. As for the procedural safeguards to be employed, unless fully other effective means are devised to inform accused persons.
The decision of the court represents poor constitutional law and entails harmful consequences for the country at large. How serious these consequences may prove to be, only time can tell. The new rules are not designed to guard any police brutality or other unmistakable banned forces of coercion. Those who use third-degree tactics and deny them in court are equally able and destined to lie as skillfully about warnings and waivers.
Silence and to ensure a continuous opportunity to exercise it. The following measures are required.
How much harm this decision will inflict on law enforcement cannot be fairly predicted with accuracy. Though at first denying his guilt, within a short time, Miranda gave a detailed oral confession and then wrote out in his own hand and signed a brief statement admitting and describing the crime. All this was accomplished in 2 hours or less without any force, threats, or promises, and without any effective warnings at all. Miranda's oral and written confessions are now held inadmissible under the court's new rules. One is entitled to feel astonished that the Constitution can be.
Prior to any questioning, the person must be warned that he has a right to remain silent, that any statement he does may be used as evidence against him, and that he has a right to the presence of an attorney, either retained or appointed. I, Chief Justice Earl Warren, will read the.
During an investigation for pure snap renew.